Welcome to this deep dive from Talk Testimonies. We look at key Supreme Court cases, trying to get you the essential understanding. Today, it's Sturgeon v. Frost.
Ah, yes, the hovercraft case in Alaska.
That's the one. So the quick version is the Supreme Court said the National Park Service couldn't regulate Mr. Sturgeon's hovercraft on a river inside a national preserve there.
Right, because Alaska owned the land under the river. The court basically limited the Park Service's reach over those specific waters. They upheld the Ninth Circuit.
Okay, so a win for Sturgeon. But how did this whole thing even get to the Supreme Court? Let's unpack that.
Well, it all starts with John Sturgeon and his hovercraft. He wanted to use it on the Nation River.
And that river runs through the Yukon-Charley Rivers National Preserve in Alaska.
Exactly. But Park Service rules banned hovercrafts within the preserve. Plain and simple.
So Sturgeon said, hold on, that rule doesn't apply to me here. Okay.
His argument was all about who owned the riverbed. He said because the state of Alaska owned the submerged lands under the Nation River, it wasn't federal public land that the Park Service could just regulate like that.
Okay, so it hinges on ownership. Federal park boundaries, but state-owned riverbed. That's the conflict zone.
Pretty much. And Sturgeon pointed to a specific law, ANILCA, that's the Alaska National Interest Lands Conservation Act.
Right, ANILCA. Always seems to come up in these Alaska cases.
It does. And Sturgeon focused on one part, Section 103C. It has these three sentences.
Okay.
First one says ANILCA doesn't change state jurisdiction up or down.
Standard stuff.
Yeah. The third one says non-public lands aren't subject to rules that only apply to public lands.
Also seems clear. What about the second sentence? You said that was crucial.
That's the one. It says activities on non-public lands within park units. Well, they're only subject to Park Service rules if the activities actually affect the public lands nearby.
Ah, so Sturgeon's saying, the riverbed is state-owned, therefore non-public. My hovercraft isn't hurting your federal banks or lands, so your ban doesn't apply to me on the water.
That's precisely his argument. Made a lot of sense from his perspective.
But the Park Service obviously didn't agree. What was their counter?
Well, they didn't think their authority just stopped at the riverbank. They pointed back to the 1976 National Park Service Organic Act.
The founding legislation for the Park Service.
Right, giving the secretary broad power to manage parks. And they said ANILCA itself backed this up for parks in Alaska. They argued regulating boating, hovercrafts, whatever, on rivers inside the park boundaries was essential to, managing the preserve.
So preserving the natural quiet, the environment. That kind of thing.
Exactly. Fulfilling the purpose of the preserve, as they put it.
This sounds like where the justices would really start asking tough questions during the arguments.
Oh, absolutely. Justice Sotomayor jumped on this. She questioned, if Sturgeon's theory held, how could the federal government possibly manage these rivers effectively? What if someone was, dumping stuff in the river? Could the Park Service do anything if it didn't immediately impact the banks?
Yeah, that's a fair point. What about Justice Kagan?
She seemed a bit skeptical of Sturgeon's reading of 103C. She wasn't totally convinced the language clearly carved out this big exception for navigable waters the way Sturgeon argued. It wasn't a slam dunk interpretation for her.
So, different justices probing different angles. What about Sturgeon's lawyer, Mr. Findley?
Findley really hammered home the idea that ANILCA was a grand bargain, a compromise. He argued Congress specifically wanted to stop the feds from slapping new regulations on state or private lands just because they happened to be inside a new park boundary in Alaska.
So the hovercraft ban was an overreach in his view.
An overreach, exactly, going beyond what that ANILCA compromise allowed.
And Alaska itself weighed in too, didn't they?
They did. As an amicus curiae, a friend of the court supporting Sturgeon. Mrs. Botstein, for Alaska, talked about the state's unique history and ANILCA's goal of protecting local ways of life.
Self-sufficiency, local control.
Right. And she argued Congress definitely did not give the federal government sole exclusive control over navigable waters inside these Alaskan parks.
Okay, so strong arguments for Sturgeon's side, emphasizing ANILCA's limits. What about the government's lawyer?
Deputy Solicitor General Needler argued for the Park Service. He went back to that 1976 Organic Act authority, saying it was broad, and ANILCA confirmed it applied to these Alaskan park waters.
And did he address the affecting public lands part?
He did. He argued a hovercraft, it's noisy, it's visible. That does affect the park environment, the experience for other visitors on the federal lands nearby. So there was an effect, he contended.
Interesting. Trying to establish that necessary link. How did the other justices react? Gorsuch.
Justice Gorsuch really zeroed in on that connection. He asked, okay, what specific impact did this hovercraft have on the water itself, the water within the federal unit? He seemed to be pushing for a very direct, tangible link, questioning the limits of Park Service power over the water column itself.
Not just the general park experience, but the water specifically.
Seems like it. And Justice Breyer, he wrote up an analogy. He talked about private land inside Yellowstone, these inholdings.
Right, like ranches or something inside the park boundary.
Exactly. And he asked, well, if there's a park-wide rule, say, about noise, does that rule count as solely applicable to public lands? If it does, then maybe it wouldn't apply to the inholding. He was trying to figure out the purpose of that second sentence in 103C. Wasn't it meant for exactly these kinds of situations?
Good question. Trying to understand the scope of solely applicable to public lands. That seems like a key phrase.
It really was. The court spent a lot of time trying to parse that. Does a rule about activity on the state-owned riverbed count as a rule solely applicable to public lands? If so, under 103C, it wouldn't apply unless there's that proven effect on adjacent federal land.
And in the end, they decided how.
They decided in favor of Sturgeon. The ruling really leaned into ANILCA being a special case for Alaska.
A unique framework.
Yes, a framework that respects state ownership of submerged lands under navigable waters. It limits how far Park Service regulations can reach onto those non-public lands within park boundaries, unless there's a clear showing of impact on the federal lands themselves.
So the ownership of the riverbed was the deciding factor, essentially.
It seems to be the core finding, yes.
Okay. Fascinating. Now, let's shift gears to our 10th chair perspective. If you were the 10th justice on this, what's your take? How would you have approached Sturgeon v. Frost?
Sitting in that 10th chair.
Well, I think the absolute key here is that balancing act Congress set up with ANILCA. You've got the federal government's duty, a really important one, to protect these incredible national preserves, their ecological health, the visitor experience, all that.
Can't ignore that.
No, absolutely not. But then you have ANILCA itself. It wasn't written in a vacuum. It was written specifically for Alaska, acknowledging its unique history, vastness, and the established state role, especially regarding navigable waters and submerged lands, and importantly, respecting existing uses and ways of life.
That state sovereignty piece feels really central to ANILCA.
It does. And that section 103C, it reads like a deliberate carve-out. Congress seems to have been saying, look, just because land or water is now inside a park boundary doesn't mean all prior state authority or private rights evaporate, especially if the feds don't actually own the land or riverbed.
So the Park Service's general desire for uniform management runs up against this specific statutory language for Alaska. Exactly. While I completely understand the Park Service wanting clear rules for managing the whole unit, the text of 103C seems pretty focused. It sets up that affecting public lands test for regulations on non-public lands within the unit. The court's focus on who owns the submerged lands feels like the right anchor point, given ANILCA's structure.
So unless the U.S. holds title, the regulatory power is different.
It seems that way under ANILCA, yes. Their authority over activities on those state-owned riverbeds appears limited by that affecting clause. It doesn't mean they have no authority, but they likely need to show a more direct impact on the adjacent federal lands to regulate something happening solely on the state's submerged lands.
Which raises questions for the future, doesn't it?
It definitely does. How will the Park Service manage activities on these waters now? They might need to really focus on documenting specific impacts, noise spillover, pollution, direct disturbance to federal banks, or wildlife on federal land to justify regulations on activities occurring on state submerged lands. It really underscores how crucial clear laws are when you have overlapping jurisdictions like this, especially in a place as complex and unique as Alaska.
So that concludes our deep dive into Sturgeon v. Frost here at Talk Testimonies. Hopefully that gives you a clearer picture of the case, the core arguments, and what it means for federal versus state power in Alaska.
Yeah, it's a case that really highlights the complexities, doesn't it? Managing these vast landscapes, respecting historical context, and trying to interpret what Congress intended with laws like ANILCA.
Definitely food for thought. Thinking about this balanced federal conservation goals versus state control over its own resources, especially water. Did ANILCA get it right? Does this ruling reflect that balance? Something to consider as we think about how we manage public and non-public lands together.